Good afternoon, and welcome to this seminar on the history of goodwill at the intangible property, delivered by Professor Barbara Lauriat. So welcome everyone, welcome Barbara and Jian. Professor Lauriat is Associate Professor of Law and Dean's Scholar in Intellectual Property, and at the Texas Technology University School of Law. And she holds a tenured position at the Texas Technology University School of Law, where she teaches torts and a variety of IP subjects. She has a degree from the United States and UK, where she taught for over a decade. And her legal research is primarily in the area of IP and often uses legal history and comparative methodologies to shed light on current legal doctrine. So let's welcome Professor Lauriat. And then after about 40 minutes, and then we'll have Professor Lee to comment, and then we open to the floor for discussion. Okay.
Well, thank you very much. Thank you to my colleagues at HKU for having me to speak. I know it's a Friday afternoon, so I also thank you to all of you for being here. It's really wonderful to be back in Hong Kong. And this project actually really brings together both the historical comparative methodology that I've used before, and also comparative in that it looks at the United States law, UK law, and indeed the law around the Commonwealth as well, including Hong Kong. So talking about the history of goodwill as intangible property, we can start with some kind of basic comparison. So for those of you maybe less familiar with kind of trademarks and unfair competition globally, some basic differences between the Hong Kong or the UK or Commonwealth trademark protection is there are some very big differences, perhaps more than in some other areas. I think we sometimes see kind of common law lumped together, or the United States trademark law used as an example of common law trademarks, when in fact, actually, the US is very different from other common law countries in terms of the way that it actually organizes the framework of trademark protection in the US. So in Hong Kong, we see that trademark protection, as in the UK and throughout the Commonwealth, primarily depends on formalities, the registration system, in order for the rights to exist in the first place. You go through the formal process of registration, you fulfill the statutory requirements, and that's what gives you the property rights. And indeed, the statute specifically states that registered trademarks are property rights. Then you also have a parallel system, the common law tort of passing off. And passing off protects goodwill in a business, commercial goodwill. And we don't have the same kind of, I mean, it varies from, that's where it varies a bit more in terms of the generalized unfair competition law. And I'm now realizing that might not be completely correct in terms of Hong Kong. It is much more so in the case of the UK. And then in the United States, by contrast, the trademark protection is really much more use-based. In fact, it's centered around, even the registered trademark law protection is centered around goodwill and as a property right that's protected by trademarks, rather than trademarks being a property right in themselves. And there is this kind of generalized unfair competition protection provided by the Lanham Act 43A. So pretty different. So Hong Kong Trademarks Ordinance, we can see, as I said, registered trademarks, clearly stated property right. We also see that there is the inclusion of the common law tort of passing off in the trademarks ordinance as well. So taking account of the possibility of this earlier right. So we can see that prevent the use of a trademark as the owner of an earlier right, in particular, the law of passing off. So taking account, incorporating into that system of formal registration, the possibility that someone could have a common law right through the law passing off. So passing off, as you probably know, it requires a misrepresentation made by the trader in a course of trade that causes damage to the goodwill of the claimant. This is sometimes known as the classic trinity of passing off. In the UK Jif Lemon case sets out this trinity of misrepresentation, damage, and goodwill. In Hong Kong, we see that this also, I want to highlight that this distinction that passing off is generally considered much more difficult for a claimant to make out the claim of passing off, both in terms of evidence and also in terms of demonstrating the damage, and that we see in case mere dilution is insufficient under Hong Kong law to establish passing off. However, to some extent, we can see that erosion of goodwill, focusing on the damage to the goodwill, could happen with a passing off action where you have goodwill in a related field if there is evidence that the plaintiff may want to be moving into that field. Now, since 1875, this has been the beginning of the move towards registration, towards formalities as being central to gaining protection in Commonwealth countries, to this focus from going away from simply having a common law right, common law protection, towards this formalities-based trademark protection that I have just been describing. And so we see that in one of the early treatises on the law of trademarks, that by the early 20th century, by reason of the statutes provided for the registration of marks, the first one being in 1875, the term trademark has become practically synonymous with registered trademark. So that started around the 1870s and has continued in that direction of kind of more formalities-based registration. So that's where I make this, one of my first claims in this project is that after 1879, the idea of any kind of Anglo-American trademark law doesn't exist, that this is the beginning of a significant divergence in the framework of how US versus Commonwealth countries protect trademark law. Now, what is this? We've seen that actually some criticisms, including from within the US, on this idea of actually this kind of common law, even though there is a major federal statute, the Lanham Act, there are some problems that are created by the lack of a formalities-based system in the US for trademarks, that this distinction between registered and unregistered marks, all covered by the Lanham Act, and yet all founded in principles of common law, that this has eviscerated this distinction between the two under the US law. And we see in Tim Dornis's work on trademark and unfair competition conflicts, he points out the development of German and European law with the American doctrines show these structural differences. So the German doctrine had considered these kind of more goodwill-like analysis, but quickly moved into this formalist privilege theory, and the US law is distinctly non-formal. So I'm by no means the first to observe this distinction. So that's the first point I'm making. Second and third, so we have the second is the US Supreme Court's decision, and we'll get to Hanover Star Milling as being the crucial case here, to identify the protection of commercial goodwill as the main justification, as the property right that is protected by US trademark law, that maintains the trademark owner's actions as the way that trademark protection is gained. So just as we see in the case of commercial goodwill. So situating goodwill as the kind of justificatory basis for protection makes this different from other systems. And in order to understand how this divergence occurred and what the implications of it are, my third point is that we actually have to look back at the history of goodwill as an intangible asset independent from trademark doctrine. Goodwill was not a handy idea to make trademark doctrine more coherent. Of course, whether it succeeded in that anyway is a good question. But Goodwill actually itself was an independent concept. It was an intangible property right dating long before the emergence of what we would consider trademark-like doctrines. So what is goodwill? We frequently see quoted Lord Macnaghten in Mueller's Margarine, the attractive force which brings in custom. But that doesn't necessarily help us. Accountants may have a different kind of definition, and yet it's all considered the same thing by the law. This goodwill, something that is a property right that is developed through a business being an ongoing concern, that has value. Simply the fact that a business has an ongoing concern, it has regular customers, that itself has value. Now, when did goodwill begin? We see very often scholars citing the 19th century. So sometimes the early 19th century, sometimes the late 19th century, as the time when goodwill as a property concept developed. So here's some other examples of this. Legal recognition of intangible assets such as goodwill, late 1800s, first half of the 19th century in one example. We see the terminology just developing in the 19th century, and goodwill being traced to Crutwell versus Lye in 1810. As a legal concept, goodwill first evolved in the early 19th century. Another example, Bob Bones' very well-known article, Hunting Goodwill, History of the Concept of Goodwill in Trademark Law, says dating from at least the early 19th century. Now, Professor Bone is correct. It did date at least from the early 19th century, but yeah, well, actually it goes back several hundred years. So it's definitely at least. So next point is that goodwill, in fact, has a very long history as an intangible, proprietor-focused, use-based asset, independent of trademarks and related doctrines. We can look to the Oxford English Dictionary. The earliest definition provided by the OED is from 1571. John Hayworth, a quarryman dying of plague, left the goodwill of his quarrel, which means a quarry, a rock quarry. So the goodwill in his business of a quarry to John Stephen. I've looked and I found some other examples from testamentary documents. So going back even further, 1542, goodwill of a farmhold. The word farmhold was a pretty broad concept at this time. It could include forge. It was kind of an early kind of property concept. And then we hear 1585-86, goodwill of the peath. I have yet to figure out what a peath is. I have been looking and looking at, I think it might have something to do with peat bogs, but that one I'm still working on identifying what the goodwill of his peath actually is. 1568, goodwill, another farmhold. So we see the use of the term, the very term goodwill, coming a little bit later. 1694, Madam Lawson, cousin to Mr. Gee, lets out to this Bolton at 8 shillings per week and 2 guineas for her goodwill. So she's letting out her hackney carriage license, which has value, but the goodwill, the intangible right in the business proposition of running the hackney carriage, actually has separate and distinct value in 1694. Now, going forward, 1725, Daniel Defoe in The Complete English Tradesman refers to, often I have known a widow get from 300 to 500 pounds, a considerable sum in 1725, for the goodwill, as 'tis called, of the shop and trade, if she did not think fit to carry on the trade. This helps us identify the social importance of recognizing goodwill, commercial goodwill, as an asset, as an intangible property right, because when people, say, for example, wanted to retire from their business, so you're a blacksmith and you're not really up to doing blacksmithing anymore, or in this case, the widow, her husband's died and she doesn't want to carry on his business anymore. There's something to sell. The value was recognized. And so people were able to, as a custom, this customary right of goodwill emerged where people could get paid, and it had this important social value. Some more examples, 1732. This particular widow is saying, it has been maliciously and falsely reported that I, widow of William Tilly, late of Arundel Street, tailor, deceased, do carry on the same trade with the intent to sell the goodwill thereof. Now she's taking out an advertisement to say, you may have heard that I was going to sell the goodwill in my husband's business, but I'm not. So please keep on coming. I'm going to keep it up. Dictionaries. So here's a French-English dictionary, describes the goodwill customer trade of a house. So 1729, and then a second edition, 1764. And this is actually very similar to the translation today. The, chalandise de maison, forgive my French pronunciation, but the habitual buying of goods from one vendor, the custom, so very similar to this idea of goodwill. So again, while early on it may have had a slightly different meaning, by the 18th century, it very much resembles what we consider today commercial goodwill. 1765, goodwill in an English dictionary defined as the premium given for being admitted into a house or shop of trade. So this is the extra you pay for being taking over a business, an existing business. Some more examples, 1756, reasonable premium for the goodwill, goodwill of the road, 1757, another to be sold, 1769. So we can see in advertising throughout the 18th century, goodwill is advertised along with the stock and trade as a separate valuable property. 1769, talking about goodwill in public houses. I've got loads of examples, in part because I've had some pushback on this project, so I'm just going to inundate you with examples until you believe me that goodwill is really old. Edmund Burke, Reflections on the Revolution in France, 1790. So pretty high profile publication here. What vestiges of liberty or property have they left? Talking about revolutionary France, saying, comparing England with revolutionary France, saying, hey, here in England, even the goodwill of an alehouse or a baker's shop, the very shadow of constructed property, is treated better than by, than more well-recognized property rights in France. Now we see goodwill compensation and government takings legislation. As I was doing this project, when I came across this, I thought, well, if anyone's going to question whether it's property, okay, we're not talking about philosophical ideas of property. I'm a historian, not a philosopher. But as far as, a solid argument that something is considered property, the government having to pay people for it when they take it away, the government's not going to do that unless they have to, unless this is a very well-recognized form of property. And this really it was included in the legislation, the fact that if I say, okay, I'm going to build a bridge across the Thames and I'm going to knock down your public house or your inn, I have to compensate you for the property, but I also have to compensate you for the goodwill. So here we have Act to Build a New Bridge in Boston, created a jury determination. So this is setting up ways of, well, how do we determine how much the goodwill in that business is worth? So special jury instructed to estimate the value of the goodwill and what it would have been worth in case the improvements intended by this act had not been in contemplation. In poetry, so here, what though I know small Latin and less Greek, good sterling English I can write and speak. I'll skip ahead. Yes, so asked my daddy's leave to study printing and got myself to my Uncle Bower's shop, where when it pleased the Lord that he should drop, the trade and goodwill of the shop was mine, where without vanity I think I shine. So poetry. Now we've got examples of the disposition of commercial goodwill in bankruptcy. Goodwill in 19th century, moving ahead a little bit in history. John Stuart Mill uses goodwill as an example of the perpetual, how certain capital may not be used at various points. Henry Dunning MacLeod, Dictionary Political Economy. And I like this example too, because goodwill is set up here alongside copyright and patent. So the future value. Another here, businesses to be sold. There's an extra category here for goodwill. Newspaper property to be sold. Yeah, more examples, more examples. Okay, but you might say, okay, I haven't mentioned any examples from legal cases, so I will do that now. Emerson versus Fairfax. This case originally reported in law French. However, goodwill in the neighborhood. So yeah, there's a goodwill in the neighborhood, and for buying and selling. So that's mentioned. I think it's very interesting. We don't have enough of the report here to know in English or law French whether it's going to, whether this really, to what extent this was about goodwill. But I think it's an interesting example due to the fact that goodwill was not translated, and goodwill, which might suggest it's a term of art. And other cases, so goodwill, again, appearing in wills, in bankruptcy disputes, in partnership disputes, and recognizing goodwill in 1783, the Marchioness Dowager of Tweedale, recognizing goodwill in a public house as an asset, and another public house case. Also mentioned in some of the seminal copyright cases of the 18th century, Tonson versus Collins. Now, Mr. Justice Yates was an outspoken opponent of intellectual property as we know it now more generally, didn't like the idea of copyright, didn't really like the idea of patents, and he lumps goodwill in there. He says, the goodwill of a shop is every day sold for a valuable consideration. That does not make it property. But he gets pushback, unsurprisingly, from Lord Mansfield, who says, oh, I remember that there was this case where this was definitely, considered property. And I think that case he was referring to was probably Giblet versus Reed, 1743 Chancery case in front of Lord Hardwicke about shares in a newspaper. So the idea of having a business interest in the newspaper, even though Intangible was something that was recognized as a property right. And also, we see an example in that case comparing the shares in the newspaper to, well, if a house were a house of great trade, one would have to account for the value of what is called the goodwill of it. So the lawyers in the 18th century are still referring to this as a sort of strange kind of merchant tradesperson's custom. It's not really something that you see regularly in the class that the judiciary would come from at that time. So they're kind of, this is clearly something they're a little bit, it's a weird thing that those peasants do, right? But there's forced to recognize it commercially. So another example from Miller versus Taylor, again from Yates, talking about the goodwill of a shop. So another seminal copyright case. And another interesting case here doesn't talk about goodwill, but in Robinson Roberts versus Weeble, 1771, where we have a full report, this was a case that really fits more into what we would consider kind of contemporary passing off. So using, selling the ladies' magazine in a rival publication, trying to pretend that one ladies' magazine is the other ladies' magazine. So misrepresenting one publication as another, and yet does not talk about goodwill in this sense. So early passing off cases we see not really talking about goodwill, such as the ladies' magazine case in 1771. So in the interest of time, I'm going to skip this. More cases of early passing off. Oh no, this is Smith versus Mapleback. So another Lord Mansfield case where he is talking about a lease, interpreting a lease, and there were how to deal with the premium that was paid for the goodwill in that 1786 lease. And 1794, some partnership cases. So certainly, while goodwill as a property right is recognized back in at least the 16th century, definitely very common by the 18th century. We see that during the 18th century, particularly the latter half of the 18th century, the courts are taking notice of it. It just appears as a form of property. They're not getting in the business of defining it as such, although Yates, unsurprisingly, tries to challenge the idea of it being property at all. But we do see it recognized, again, throughout the 18th century. So I hope you now all accept my premise that goodwill did not emerge, whether in law or as a customary property right in the 19th century, but indeed is well established in the 18th. More examples. More examples. And more examples. Okay. So goodwill is a property right, very clearly recognized in the 18th century, but conceptually distinct from trademark protection. And usually wouldn't have come up because very often it was attached to physical property. We do start to see the overlap happening with regard to periodical publications, which is why I mentioned that Ladies Magazine case, where they start to see, well, actually, this idea of protecting the right of a periodical publication from other misrepresentations that something else is the same periodical, where the premises, the physical place that the business happens, is completely separate from the business of the periodical. We see that this starts to connect this with the idea of passing off and a goodwill in a trade and copyright, that this is this other kind of thing. So trying to figure out where this fits in. Churton versus Douglas, we can see another comparison of this idea that goodwill, we might actually change, it might be connected with the name of a business. So goodwill is very much connected with the name of the business, and that might that might not be the name of the current owner of that business. And yet it's part of that established ongoing business value. And so the 18th century is where we start to see this connection made in the cases between the early common law right of goodwill and how it relates to trademark rights. We see this also 1825 in the Snowden versus Noah case of the goodwill of an established trade, the custom of it in the rights of a publisher. So connecting this idea of goodwill with nascent trademark protection. Now, skipping ahead so now we've established that goodwill emerged separately from trademark law. By the early 19th century, we start to see some courts making a connection between trademark law and protection of goodwill. And in 1879, there had been US federal legislation on trademark registration, but this was rejected by the US Supreme Court. And in that case, they said, under common law, exclusive right to a mark, so trademark protection, grows out of its use and not its mere adoption. So here's the US Supreme Court, 1879, saying, well, we can't have federal trademark registration, but don't worry, guys. Don't worry, because trademark rights grow out of use anyway. You don't need a registration system. So, yeah. Now, by contrast, the UK, and then later as adopted in other Commonwealth countries, the tort of passing off emerged separate because from 1875, we have the registration system. And so if the registration system is based on a statute, what happens to everything else that isn't covered by the statute? And so that law of passing off that we see the example of from the Robinson versus Weeble case in 1771, as far back as the 18th century, we start to see this divergence. We've got registered trademark rights on one side and passing off as a tort protecting common law rights on the other. But wait a second, if we're saying that the trademark rights are based in registration, then what does passing off actually protect? As a tort, as something that we may seek injunctive relief to protect, theoretically, if we're going to have a doctrinally consistent argument or basis for this tort, it should be a property right. But trademark rights are now something else. Trademark rights are a property right that's created by statute. So what is this passing off thing protecting? So the solution to that was to say, oh, commercial goodwill, that's what we're protecting through the law of passing off. Trademark rights through registration, through formalities, that protects trademarks as property. Passing off protects commercial goodwill as property. Okay, that's a nifty little solution to that. But this is something that does emerge in the early part of the 20th century. Now, US law goes the other way because the Supreme Court in 1879 has already said, well, wait a second, trademark rights are entirely gained through use at common law. We don't, you know, you don't get them through registration, you get them through use. This was solidified in Hanover Star Milling versus Metcalf, where the Supreme Court tries to deal with this and says, okay, well, what's the basis of the property for the trademarks? Well, trademarks aren't property. We're not going to go so far as to say that trademarks are property. We're going to say that trademarks are associated with goodwill, and goodwill is property, because the English courts already said that. But the English courts at this point had already diverged. They'd been had been two separate systems already for decades. So it's an odd thing for them to do in some ways. And yet they completely misstate this idea that the English courts, it has often been said there was no property, whatever, in a trademark as such. Actually, no, there were some cases that said that, but there were just as many that said it was. And by the early 20th century, it was pretty solid that the basis of trademark protection rests on property. So, but yet Hanover Star Milling Company versus Metcalf goes even further. Common law trademarks are of course to be classed among property rights, but it's based on the trade reputation and the goodwill that flows from it. The trademark is merely an instrumentality of that goodwill. So coming back to this distinction, we can see how the different ways that goodwill, which historically had its own meaning as an intangible property going way back, that was separate from any kind of trademark or unfair competition doctrines, was incorporated into different parts of the legal systems, different parts of trademark protection in the United States versus the UK and then other Commonwealth countries. That instead of having this formalities-based trademark registration creates the right, and then you also have this parallel common law system of passing off, which we do have to kind of account for within the registration system. So we see it in the statute that those earlier rights can be used against a potential trademark registration. But we do have these divergent kinds of protection where goodwill is the center of passing off. Goodwill is what is protected by the tort of passing off. The trademark property is protected through the trademark statute. And then in the United States, it's just all jumbled together, and yet everything is justified by protecting goodwill. And goodwill, as we see, is very proprietor focused. When Frank Schechter writes in 1927, Rational Basis of Trademark Protection, actually, if you read Schechter from the perspective of, well, you know, the Supreme Court has recently said that everything's all about goodwill all the time, then dilution actually makes a fair bit of sense. It's use-based, it's proprietor-focused. We can see how those kind of dilution kinds of harms affect the goodwill of a proprietor. So thank you very much.
Barbara, I'm really happy that I suggested that you talk about this rather than SEP. Really a fascinating historical account of this very valuable topic, and I think it really fell a little bit gap here because we are talking about goodwill. We talk about we talk about a lot when we talk about the trademark, but I think including myself didn't really understand too much about the close relationship, particularly historical development. So I'm really very appreciate what you have talked about today. So I think we will give about like 10 minutes to Professor Lee for the comment.
Sure. Thank you, Yan Hong. So, Barbara, thank you for the great sharing. I'm not an expert in legal history, but I did learn a lot. So my very limited knowledge about trademark law and unfair competition is more about modern times, but we do see some link here. So one thing that I'm really curious is that, so if goodwill can become kind of like guiding principle. This is what we learn from the history for trademark. So how do we redefine the policy goal of trademark? Because I somehow remember there is a debate, so which is that whether the policy goal of trademark is to protect the trademark owner or ultimately the consumer. So if we focus more on goodwill, does that mean that consumer would be less important here? So that is kind of like my first question. And the second question that I have is that, so my impression is that goodwill is very closely associated with the business reputation. So is that right to say that goodwill is actually just a business reputation, which is subject to different kind of legal protection? Because even in civil law system, business reputation would be protected under different laws and the reputation. But one thing that would be very interesting to see is that the way we protect the reputation of an individual is very different from that for business. So for individual, just like the common law system, so we have different ways, the torts, defamation, etc. But we don't treat that as a property right. So that looks more like kind of like the way that we need to defend ourselves, more closely related to personal dignity. But when we kind of like expand that as a business reputation, we do see a positive commercial value here. I'm just thinking because this is about history. So in ancient times, very likely, most of the businesses were not incorporated as an entity like today. So probably we start from individual because all the business transactions come from personal or interpersonal relations. Then to a certain degree, that personal reputation might expand into the domain of business reputation or the so-called that goodwill that we understand. And the other thing that I feel really interested was I was a merger acquisition lawyer 20 years ago. So I did a lot of merger acquisition cases, and we need to work with these investment banks and CPAs. So the way they do the transaction is that they need to do the value of the company. So of course, lawyers might try to justify that financial calculation, but of course they have a very rigorous way to calculate the value. And every time, if the transaction is successful, so which means that the acquirer was willing to pay more than what we calculate on the paper. That is the so-called premium. And then I somehow remember that I asked my, when I was a training lawyer, I asked my principal, that is my advisor. I asked them, so how do we kind of like treat that differences in the value on paper and the value in real deal? And the accountants and investment bankers told us that, so there's an item on financial statement that is a so-called premium. But the way my advisor told me, so who was a very senior lawyer, and she told me, that is the value of trademark. So why people are willing to pay more than what appear on this financial statement or different ways of a method to do the value. And then that is the first time that I kind of like learn about the relationship between trademark and goodwill. But I always feel something wrong. I don't think that's really about trademark. I think that might be just like a lawyer's misconception of the business value. And I'm also very curious because the first case, because you talk a lot about how people use the term goodwill, of course, in different disciplines, and then you start to talk about the case. And the first case that you mentioned was a French case. Was not a French case. Oh, it's English case. Yeah, because the 1666, I thought that was, all right. Okay, all right. And again, let's come back to this. So which is that we actually work a lot on different aspects of IP with regard to the relations to torts. So for copyright, for patent, we adopt different doctrines or we were hugely influenced by torts. But after hearing your presentation, I thought, I'm not sure if I'm right, but I just have that feeling, oh, trademark might be the IP discipline that would be mostly influenced by torts. And also, something that might be relevant here is unfair competition. So I feel a little bit confused because then I might need to rethink about the relationship and the policy objective between these old disciplines, which includes torts, unfair competition, and of course, trademark law.
Well, thank you very much for those questions, and there's some great ones there. So hopefully I can remember them all. I should have taken notes. But so first of all, the point about the question of what is the purpose of trademark protection, and this has been a big debate, particularly in the US, kind of back and forth. And some of those arguments have been historically based, which is one of the things that got me started on this project. And the fact is that, and Lionel Bentley and others have looked at the history. It's very clear that both ideas of protecting the business proprietor and protecting consumers, we see strains of both of these justifications dating back to the earliest cases that we can recognize as trademark law really. So I think if one is going to take a historical approach, yes, I think historically it was justified through both of these things, and whether or not how it was done historically should make any difference to how we do it now. In a common law system, often it does, but even as a historian, I would say, well, there's absolutely no reason we need to be bound by that. Whatever, we can move forward, and trademark law has evolved a lot anyway. Now, but the focus on Goodwill, however, Goodwill was always proprietor focused. So this is my point about the US system. It's by adopting Goodwill, particularly as the central fundamental basis for its trademark protection, that even if we do start talking about kind of a more utilitarian justification, you're sort of saddled with this idea of Goodwill, which is more comprehensive than many kind of early trademark cases were as far as the limits, the scope of protection. So if we start thinking about Goodwill is a bigger idea, which kind of comes to your second question about Goodwill. Well, kind of second and third, Goodwill in accountancy, Goodwill in how do we see it today? Now, this is an interesting one, and one of the great sources for this project was looking at some of the accountancy scholarship, particularly from the late 19th and early 20th centuries. And we do have, and I haven't mentioned it, but case law from the 19th century where dealing with goodwill and taxation, and goodwill was indeed taxed as property under many of the Stamp Acts in the 19th century. So we have cases on that. And so the accountants were having to deal with it. And while they sometimes had different definitions, there have been cases, in fact, even one of the most recent ones was a British Court of Appeals case from a few years ago. I can't remember the name of it, but it was interpreting goodwill as it was included in a contract. And basically there were two kind of interpretations of what it meant for the purposes of the contract. And the Court of Appeal said, well, it means the same thing that it means in passing off cases. And we have lots of definitions. So that's what it means. It doesn't mean it's a different thing for purposes of contracts or accountancy. It's the same property right. Now, as far as what does that encompass? Is it just the trademarks? Well, we do see, it's used in that way sometimes, particularly now that the US law is so goodwill focused that it's kind of considered almost inextricable from trademarks. I think if we go back historically, it was used in lots of different ways, and it did encompass other things clearly. It encompassed the idea of simply being a going concern, having existing business relationships that aren't necessarily consumer relationships. Maybe you have a really good supplier for your ale. I mean, in a way, that's part of the value of the business already being an existing business, and people are willing to pay for that, pay extra on top of the goods or any right to the lease, et cetera. So that's that question. Oh, the early case that I mentioned from 1666. Sorry, I should have explained that for the non-legal historian. So it's an English case, but early reports up until really around that period, the late 17th century, were usually in Latin or law, what's called law French, which isn't really French or language. No, it was what the kind of the lawyer, the legal profession. You think of the legal profession today, we like to use lots of terms of art so that we get paid the big bucks, right? Because otherwise everyone could understand it. But no, so they used law French, the courts and the legal professionals very often, and it's a strange combination of early kind of Norman French and some Latin terms and some English terms. I'm by no means an expert. If anybody ends up having to look at these early cases, Sir John Baker has a kind of guide to law French grammar that I found useful, and I'd studied a little bit of Latin, but no, I mean, it's hard going, and please don't ask me to translate anymore than I have to. Yeah, so that's what that is. It's an English case, but what I found interesting was the fact that Goodwill was not, they didn't try to put that in Latin. They didn't try to put that into, so it seems to have been treated as a term of art in that early case. So that which I found interesting. So then, oh yeah, so and in contracts, the kind of the premium paid for a business. Yeah, so I've talked to friends who kind of are in investment banking or and they say, oh yeah, the Goodwill, we know about the Goodwill, and it's a line item. It's we have to account for the Goodwill, but they're not really clear on it. So it is interesting. I guess it does sort of mean whatever. Yeah, it's like the trademarks, the reputation, and that you were talking about torts, the tort influence on trademarks. Well, I think there is something to that, and also I think just the economic torts in general. I want to look at, because you were talking about defamation, and of course there is the economic tort of trade defamation that emerges fairly early on and really is connected to some of these earlier doctrines. The idea that you can't, and in a way, I think that's the early cases on that are just as connected to some of the early cases on trademark protection. This idea that, well, if you can't say bad things about other people's businesses that aren't true, and you can't misrepresent your things in a way that's going to then harm that. So I think that does, the trade defamation and other economic torts do kind of have very similar doctrinal roots. Yeah, there is definitely something there in the history.
Yeah, can I have one more question? Yeah, sure. Yeah, so it just strikes me that in Chinese trademark law, Yahong and Danny certainly knows that we have a very similar approach, which is to protect well-known unregistered trademark. And the law and the judiciary develop a number of criteria to determine the degree of well-knownness. And that seems very similar to the British way that you just mentioned. So of course, the court might consider, when the business was built and how popular that was and how's the reputation. A major challenge in the past decade faced by Chinese courts is that there's always a debate to what extent the court needs to consider the geographic scope of the reputation, because a business might be really reputable nationwide, and whereas some other small business might be famous just in, for example, in a small valley in Wales. So I'm just curious, how did the British court treat this kind of differences? Did it also consider the different degree of the geographic scope of that reputation?
This is a very dangerous question to ask me. I don't know if you knew I had a piece on this. Okay, so as far as the protection for well-known marks, I mean, of course, that comes from the Paris Convention, so making a commitment to the protection of well-known marks. And the UK is arguably very bad on this in that it has, it does have a provision, I think it's 57 in the Trademark Act, for well-known marks, but that's, as far as I know, never been successfully used. And then otherwise they would rely on passing off. Now, so exactly, you say, well, what's the geographical scope? So in contrast to, say, India, Singapore, Australia, New Zealand, the UK, and fairly recently in the Starbucks case, Starbucks, the Hong Kong company, not the coffee company, that they said that they took the hard line on locality of Goodwill. So whereas it sort of makes some sense, but I really thought they were going to go the other direction, but they didn't, and that case drives everyone crazy. But yeah, the UK Supreme Court went for a pretty strict, there have to be consumers within the jurisdiction of the product or service for there to be Goodwill recognized in that jurisdiction. But again, that's a minority position in the Commonwealth. But it's a very interesting question about this connection between what are well-known marks and China, it probably has more actual guidance on this than many jurisdictions where there's very little.
In China, if you don't have a nationwide reputation, you still have a right. So which is a very kind of like a, I would say, not very positive right. So which is that you can maintain using that mark because you have built some goodwill associated with the mark, which means that other people might not ask the trademark office to cancel your mark, but you can do nothing with like a really new registration or registration of the mark. But if that is a mark with well-known status, so you have a more positive right. You may even ask the trademark office to cancel the new registration.
This is an interesting point too, because as much as I've tried to make a distinction between the kind of formalities and registration-based systems in the US, where it's just all kind of blurred together at this point, of course, even the kind of formal registration-based systems do have to account for some kind of rights that emerge in a kind of common law-like way, some kind of use-based rights in their systems, because often that is how businesses develop. And so there is this, I guess this is just one of the really interesting and complicated things about trademark law is how do you incorporate these use-based rights into a formalities-based system. And we also see this, so not just with kind of well-known marks or marks with a reputation, and some systems do divide the two and for different purposes, but we also see this with the increasingly including provisions about bad faith registration. And that itself is more of a use-based question. That's yet another example of, well, there is this inherently kind of use-based part of trademarks. Trademarks use is very important. And yet that can work, even if sometimes a little uneasily within a formalities registration-based system. I don't know if you've gathered at this point, I'm kind of more of a fan of the formalities and registration-based systems, and it's been a bit of a shock to my system moving back to the US and teaching this, but I remember, I think the first time it really did shock me was when I was teaching international and comparative trademark law at King's College London for many years, and just particularly trying to explain how the US law works and trying to even fit it into my kind of my course. Where does this work? We have, I couldn't divide it up into, oh, well, now we do the registered rights and now we do the unregistered. And I remember once, this really, this very, very good German lawyer that was one of my students, and she came up to me and was asking these questions about, well, you said that this defense under the Lanham Act, applies to, unregistered marks and registered marks. But if you look at the statutory language, it's only talking about, unregistered marks. And I said, well, yeah, but we still apply it anyway, but she said, but the statute says this. And I'm like, yeah, but the courts say that. So, and it was such that was a moment where I was like, wow, this really doesn't map very easily onto, comparative study with other systems.
I'm aware there's only 5 minutes left, and I will exercise my my privilege here to extend 10 to 15 minutes. Yeah, I open to the floor.